This is an appeal in the matter of Young versus Downey.
Good morning, Miss Studd.
Good lady. The appellant, Sarah Jane Young, is the child of Lance Corporal Geoffrey Young, who, together with Anthony Daly, Lieutenant Anthony Daly and Trooper Simon Tipper, were killed when the bomb exploded in Hyde Park in July of 1982. The IRA claimed responsibility for that bombing. The claimant was 4½. She had a close relationship with her father. She watched from the nursery at the Hyde Park barracks when he left on his horse, and he turned to her and she waved goodbye. She subsequently heard a huge noise. The building she was in shook. She saw soldiers running out of the barracks, and she saw soldiers in the same uniform as her father had left in, coming back in, embedded with nails, and one of the soldiers she recalled having nails sticking out of his hands. This was a split trial. Mrs Justice Yip dealt with the issues of liability and limitation, and it was then heard before Mr Justice Martin Spencer some while ago now to consider quantum. The learned judge concluded, in relation to whether or not the appellant was a secondary victim, that all control mechanisms had been met, save that, in his opinion, the claimant did not appreciate that her father had been killed, and therefore she was not to be considered any differently to the bystander, and she was unable to recover as a secondary victim. Just to deal with the direction of travel, what I want to do is look at the chronology, which is behind the bundle at tab 5, and then go to the judgment of Mrs Justice Yip in two material respects. Then I'm going to come to look at the judgment of Mr Justice Martin Spencer at tab 7, and then turn to the law. But the two material questions for this court are: does the claimant, as the child of the deceased, qualify to be considered as a secondary victim by reason of her proximity of relationship per se, provided all the other control mechanisms are satisfied, or is that relationship insufficient and subject to additional proof of actual knowledge that her father was the victim? And secondly, where the defendant absents himself from the hearing, what approach should the court take to uncontroverted expert evidence? If I can take you, please, first of all, to tab 5 in the core bundle.
You can. Can I just tell you what concerns the court? We've done quite a lot of reading, so
yes,
we sort of do understand the issues. I'm a bit concerned about the different formulations of the word used by the claimant, the words allegedly used by the claimant, upon
yes,
which both the judge and the expert relied in different places. And it would help me anyway to be shown precisely what the evidence before the judge was and what evidence the expert took into account
yes,
of the events which occurred, so far as we know them, and bearing in mind, of course, that it was all recollection from years and years before. And the second thing that would help me when you come to the law, obviously this court is fairly well au fait with the case of Paul,
yes,
and the issues surrounding control mechanisms. Submissions on how we should approach that would be helpful, particularly bearing in mind that the one thing control mechanisms are not is to be construed as some kind of deed. And it seems to me we are at quite severe risk of losing the wood for the trees if we start descending into analysis of what one judge has said in one case and what another judge has said in another case, we now need to look at the Supreme Court's judgment in Paul and to acknowledge that there has never been a case in which this issue arose, as far as I understand it.
That's right.
So we need to understand what the premise of the position is on proximity. So that would be helpful if you could address that. But in the first instance, I would have thought the evidence. But you want to go to the judgments first, and that sets the scene nicely, so let's do that.
Well, I'm very happy to look at the evidence if that's going to help you.
When you come
by way of
to
a
it, yes, please.
preface.
Yes.
I know, my lord, that you asked for the statement of Sarah Jane Young this morning,
Yeah.
and I've provided the first witness statement to my lady and my lord.
You then got the second one as well.
The second statement really deals with the issue of limitations. I'm not sure it's going to help you very much,
All right.
which is why I've just left it. It exhibits the reply, and it exhibits the judgment of Mr. Justice Sweeney at the Old Bailey,
Okay.
which formed the basis of the limitation issue.
And that was
But this witness statement you've given us is dated 22nd February 2019,
Yes.
so it was not in existence at the time of Dr. Cooling's expert report.
I can check, but I think that there was a draft statement in place because Dr. Cooling if you could just leave that with me, my lord, and I will just get my instructing solicitors to check.
Well, can I just say this? It's normally incumbent on an expert to identify at the start of their report the documents
I was
they're
just
relying
going to
on.
look at it now.
He doesn't identify a witness statement at the start of his report. He refers to 3 separate sets of medical records.
Yes.
And that second statement prepared by the claimant, that was very much for the trial before Mrs. Justice Yip, because limitation was a live issue.
Absolutely right, yes. And it doesn't, I did have a look at it just before the hearing this morning, and it doesn't provide any assistance as far as relationships or what she witnessed on the day is concerned. The statement from Sarah Jane Young, dated the 22nd of February 2019, sets out her recollection as of that time. And that is the content of the statement, which is summarised by both Mrs. Justice Yip and Mr. Justice Martin Spencer in their judgments. And so far as Dr. Cooling is concerned, he interviewed the claimant. You can see that. At paragraph 2, my report is based on a home visit that took place on the 15th of June 2017, and then the contemporaneous records.
When you say, yes, but he doesn't set out, or where does he set out the history she gave him?
I think that's at page 18, paragraph 60, well, probably 59, following. At interview, she told me that she
If we look at, yes, sorry, he says, starting at page 14, paragraph 48, interview with Sarah Jane Young.
But in fact,
And we go over
Stop.
But, that doesn't, classically you see a history, and there's a family history at 54.
yes, and then 57.
well, hang on, what about 53? because he actually stops because she becomes tearful and distressed.
Yes. And then he continues at paragraph 57. And what happened?
Well, 58.
Yes.
At interview, he, that must be a slip for she, mustn't it be, told me that at the time she was living with her parents, after the bombing event, she remembers talking to her mother, and she kept on saying, Dad should be home now. That's she, the mother, presumably.
No, that's she, the child.
What is it? It's not a natural reading of that.
Well, if one reads into the next sentence, she again is used, and that clearly is a reference to the daughter. She was puzzled and worried about what had happened to her father.
Then there's reference, but that there is a history to some extent at para 13, taken not from her directly, but from a history that she had given in a letter which which Dr. Cooling refers to.
Sorry, which bit?
That was in a medical letter.
Well, it's a letter from the community,
Yes.
from the community. It's page 78 of the bundle, paragraph 13 of the report.
You're looking at the
78
second
in the bundle.
report.
There's only 73 pages in the bundle.
Oh, my bundle has 78 pages. Well, my bundle has 129 pages.
Yes, I think you're in bundle. Are you in bundle 1?
In the core.
The core bundle.
Yes.
Yes.
Sorry.
Yes, I'm sorry, that's not very helpful, is it? Because the report is attached to the pleading, and that's just where I naturally
Yes.
found it. But we've got it in two places.
Yes, we've got
I'm
it.
sorry if I confused
Well,
you.
that's probably foolish of us because it should only be in one place in the bundle.
Well,
How?
okay. Well, I'll by paragraph number. It's
Yes.
paragraph 13,
Thank you. Yes.
and that doesn't say anything about what the mother said. I'm not saying this is. I just want to get a picture of what material was before both the doctor and the judge.
Yes.
But as you rightly say, 58 is his evidence about the history she gave
Yes.
him, and the key phrase is the one that we looked at.
Yes. And it's been consistent from her, and of course this was because there was no defendant, respondent. The evidence was not an issue. And we're going to
Except
come on
there is
to
a
that
big-
later.
There is a big difference, well, there is a difference anyway, between what the expert records, Dad should be home now, and what the statement says, Daddy should be coming now. Maybe there could be lots of arguments about whether that's a material difference, but they do seem to be used interchangeably, because when you get to the judge records at paragraph
10.
10,
Daddy should be coming now.
he says, yes, I'm just,
Page 38.
yeah, and he says, Daddy should be coming now. is the statement.
And that is the statement which the judge says at paragraph 10 he accepts.
Yes.
But apart from the difference my Lord has referred to, assuming you're right that she, in the medical report, para 58 of the medical report, refers to the claimant, she kept on saying, the phrase she kept on saying is much more obviously indicative of anxiety
Yes.
than the phrase in the witness statement, which is, I remember telling my mum afterwards, Daddy, she'll be coming now, which is open to a lot of interpretation.
Yes. I should perhaps say this, my lord, that I accept that in an ideal way, it may be that a child psychiatrist should have been instructed here, because obviously what a child says in response to extreme anxiety and stress is going to be different to what an adult might say in response to the same events. But the difficulty that we have here is that at this stage, the appellant was legally aided. Public funding had been achieved after a judicial review. There was no defendant present. And the reality is that had we requested additional psychiatric evidence from a child psychiatrist or psychologist, we would have been very unlikely to get it, because we had Dr. Cooling in place with the evidence, such as it was available, which on its face satisfied the criteria. And we, because the defendant respondent was not attending and not represented, the usual course would be to tender that evidence as part of the decision on quantum. And it would be very unusual in those circumstances to incur reasonably substantial additional public funds in order to obtain evidence that, on one view, would be regarded as unnecessary. So the position was slightly unusual in that respect. It's unusual because you have a child who's now bringing the claim when she's very much an adult. And so for perfectly logical reasons, the initial approach was to an adult psychiatrist rather than a child psychiatrist. And I should say, I'm saying this in order to just give the picture to the court about the position that the appellant was in, and also that, of course, Mr. Justice Martin Spencer did not say that he did not value Dr. Cooling's report, or he disregarded it because he did not have the requisite experience. In fact, far from it. He accepted that Dr. Cooling was able to give the information.
Since you've raised this, can I just understand what happened?
Yes.
Surely it goes further. If I've understood correctly, it was him who asked for Dr. Cooling to come and give live evidence.
He did.
How did that happen?
On day one of the trial. And I've tried to remember exactly when, but I think it was sometime around lunch, so either just before lunch or just after lunch on day one. He raised the issue about whether or not the appellant would satisfy the control mechanisms as a secondary victim. And as a result of that, we contacted Dr. Cooling. This was a remote hearing. We contacted Dr. Cooling and established that he was available to give evidence the following morning.
Who was... Sorry, my dear.
Did the judge indicate the parameters of the evidence he wanted to hear?
No, he didn't indicate the parameters, but he did say that he wasn't satisfied that she fulfilled the control mechanisms. And that's why in my argument, which he refers to, I was very anxious to establish the aftermath point, because I thought he was going to take issue with whether or not she was a witness to the aftermath.
I'm sorry, I may have misheard you, but you said something slightly different from what the judge said. The judge says that he asked for Dr. Cooling.
He did.
And what I understood you to be saying is you thought
No.
it would be a good idea for him.
No.
He said, can I hear from Dr. Cooling?
Yes, I think he did say, can I hear from Dr. Cooling? Or I think he may have said, is Dr. Cooling available? And as a result of that, he was available and he attended remotely on the second day of the hearing.
And we don't have a transcript of.
We don't have a transcript of that.
But what happened? Did you call him then in chief, or did the judge ask questions? What
The
happened?
judge asked some questions.
Did you ask any questions?
I asked some questions. I did ask some questions in order to deal with the control mechanisms, such as we were concerned about them. And the judge asked the questions particularly about what she would have understood. And you can see what the learned judge took into account in relation to that, which very much accords with the conversation that took place.
Where are we looking?
Paragraph 12, is it?
Yes.
That is the only. We've got to take it from there because we have no other record of what he said. So
No.
This is the authoritative account of what Dr. Cooling told the judge.
It is. And I'm bound to say, my lord, that when I reviewed the judgment, there certainly wasn't anything in the judgment that we considered to be inaccurate or wrong.
No, fine.
And these would have been questions from the judge.
They were questions from the judge.
And what has come out of it, I hadn't fully understood. There's quite a lot of discussion here, which the judge records, presumably between himself and Dr. Cooling, about the significance of the phrase "Daddy should be coming now," whatever
Yes.
it is. But what is of interest is that Dr. Cooling had heard her say he wasn't working just from the witness statement, which indeed he hadn't seen.
No.
He was working presumably from his own report, where he had recorded an equivalent, though not identical,
Yes.
account
Yes.
from her. And that's presumably what he was basing his opinion on, much
Was.
more than on a bit of paper, which might not even have been shown.
And he didn't demur from his conclusion in his report that what she witnessed was causative of her psychiatric condition.
But he wasn't really being cross-examined about that. I mean, that wasn't what he's being called to deal with, was he?
He was being called to deal with what she would have appreciated.
Yes, so he wasn't being, you say he didn't demur from his previous evidence on causation, but he wouldn't have. That wasn't, there was no one to cross-examine him. The judge wasn't worried about that. I'm sorry, I just want to make sure that what the scope of him coming was. He wasn't being asked about causation, was he?
Well, the two went together because the judge's view was that she couldn't have appreciated that her father had been injured because she hadn't actually seen her father injured. So it was very much bound up in the same issue. I mean, the difficulty here, my lord, is that either this psychiatric illness was caused by what she witnessed and saw as a result of nervous shock because she thought her father was involved in it in some way, or it could only have been a grief reaction because it seems to have evolved very quickly after the incident.
In theory, it could have been caused by her seeing a horrible accident and soldiers rushing back with blood and nails in their hands, but with not a father element in it. It
could. But But I don't think that's what the judge was saying. The judge was saying that actually she couldn't have associated what was happening with her father. And without that association, she couldn't recover.
I mean, the judge actually talks about causation and Dr. Cooling specifically at paragraph 19, where he says, in my opinion,
Yes.
he records what Dr. Cooling had said, and said that, in his opinion, the PTSD, etc., would not have manifested but for what Sarah Jane witnessed in the immediate aftermath of the Hyde Park bombing, when she saw the physical condition of the returning soldiers, which doesn't make any reference to the relationship.
No.
But when he's concerned, he then later deals with control mechanisms, not until paragraph 22 and following. But when he's dealing with the evidence, at paragraph 11, he records, having dealt with her statement, set out her statement in full and said he accepts it, he makes two comments that I think are significant in paragraph 11 before dealing with Cooling at all. He says, I'm sorry to go on, but I think it's just important to be analytical. He says, she does not say, at the end of the first sentence, that she remembers associating what she saw and heard with her father, or appreciating that her father was or might be involved. He says he doesn't find that surprising, presumably because of his knowledge of 4-year-olds. This was a 4.5-year-old, I think. But he says, then, as far as she was concerned, she had waved him off, he had smiled at her, and he would be coming home later.
Yes.
Now, that seems to me to be taking the cart before the horse. He is reaching a conclusion as to what her view was about the thing. And then he goes on to deal with Dr. Cooling and his expertise, and says what he says about what she would have appreciated, and what he said about Daddy should be coming now. And he records that he thought that this was the child seeking reassurance about her father, reassurance which was not forthcoming. And then he, the judge, says, well, I've got difficulty with that, and takes the semantic point. Had she said, Daddy is coming soon now, isn't he? That might have betrayed anxiety, but simply saying Daddy should be coming now indicates to me that the claimant was expecting her father home soon. Now, I mean, all that is a very, slightly anyway, unsatisfactory way of dealing with it.
Yes.
Because he's interspersing, as judges sometimes do, what you think about it with what the evidence was.
Yes. But also it reveals, there's a danger here in assuming what you know about 4-year-olds and the way their minds work in relation to the impact of trauma. Because no doubt my lordship and my lady will know that trauma can affect very young children, just as it can affect teenagers and adults, but it affects them differently. And the reason for having the expert psychiatrist is to assist with that, and save exceptionally, it is not open to the judge to say, well, that wouldn't be how my grandchild would respond.
Can I
example.
ask you, and I think that's obvious, if I may say so, that the judge is not required to say how he or she feels their grandchildren might or might
Yes.
not react. But can I ask you a question? If the child had been 1 year old or 6 years old and had been in every respect the same, except obviously not running around and not pressing her nose against the window, but had witnessed in the same way
Yes.
the father leaving the bomb and the soldiers coming back, of course we wouldn't know. We wouldn't have a
No.
spoken
No.
reaction. Could this claim succeed?
Very unlikely.
Because
Very unlikely, because if you, well, first of all, you would have to have a psychiatric manifestation of what had happened, and you would have to be able to divide that from a change of circumstances at home, and you would also,
can I just direct your mind on the grounds of proximity?
yes,
Let's assume causation.
yes,
I mean, I think what you make a very strong point saying that adults don't really understand that trauma can affect children in
Yes.
a completely different way. None of us is experts. Let's assume that such a trauma could affect a 1-year-old child.
yes.
On the grounds of proximity, can the claim succeed as a matter of law?
Well, it could succeed, but it would be very unusual, wouldn't it? Because, I mean, here we've got a younger sibling who was present, who had no reaction. So it would really depend on the expert evidence showing that there was an association possible between that child and what had happened. So I don't disagree that this 4-year-old has to have an appreciation of what had happened. The difference here is that we say she did have.
What do you mean by of what had happened?
Well, if so, this appellant, on her account, associated what she saw, soldiers going, her father, one of the soldiers in a uniform, leaving the barracks in a totally normal way, to a very few minutes later, a large bang, a shaking of the building, people running out, soldiers in the same uniform that her father had left in, coming back in. So there's an association there between what she is witnessing and her father. Without a doubt there is.
Sorry.
The fact that she doesn't say, I saw my father or I thought my father, in my submission is neither here nor there. She makes the reference to her father coming back. The Child Bereavement Trust absolutely recognises that as an appropriate response from a child of this age.
What the Child Bereavement Trust?
Yes.
Well, that's not evidence in the case, is it?
Well, we've enclosed it because we needed to have a look at, we had no evidence at the hearing about...
So we can't see it now, can we? If there wasn't evidence.
It wasn't evidence in the hearing, but the only reason why I would invite you to give it some consideration is because it illustrates, in my submission, exactly what went wrong with the judge drawing the conclusion that he drew. Because if there is public documentation that shows that children of this age, their response is about, are they coming back? Is the person that you love coming back? It's not, are they dead? So it illustrates in my submission exactly why the judge shouldn't have put his own interpretation on this and should have left it to the expert.
Well, this Child Bereavement Trust material is not on my desk, as it were. Where do I find it?
You find it in the last tab on the...
Of what? Of the supplementary bundle?
In the authorities bundle.
Oh.
And it's at page 395 electronically.
Right, thank you.
And at the very bottom of 396, it deals with children aged 2 to 5. And in the middle paragraph, at the top of page 297, their limited understanding may lead to apparent lack of reaction when told of a death. They may ask many questions about where the person who's died is and when they will come back.
Yeah.
It's dealing with a slightly different point, though, isn't it? It's when you've been told someone's died and they don't know what it
Yes.
means, and they say, when did he come back? That's not really the same point.
No, I agree with that to some extent, but it does illustrate that the point that the judge was relying upon to give credence to the suggestion that she could not have known that it was her father may be incorrect.
Isn't your stronger point that here is an expert giving precisely that
Yes.
evidence to the judge?
Yes.
He shouldn't have disregarded it.
Yes, that is the strong point. But I think it helps just to look at whether or not his decision making is flawed by also seeing, in very broad terms, the sort of reactions that young children have in these sort of situations.
It's extraordinary how little knowledge ordinary people really have of this subject.
Yes.
And that tells me that,
Yes.
if nothing else.
Yes. And I know I was a little facetious, my lord, earlier about one's grandchildren, but you can, if you're going to do what the learned judge did in this case, it is only by personal experience. You can only draw from personal experience. And that is actually crossing the line here.
Well, it's dangerous.
Yeah.
I mean, there are things you can take judicial notice of, like there's a Tesco's opposite here.
Yes,
I mean, I don't know if there is, but there must be.
there is.
There is. Okay. I never remember if it's Tesco's or Sainsbury's, but
Yes.
you can take judicial notice of the fact that there are Tesco's in the area. But I'm not sure you can take judicial notice of the finer points of child psychiatry obtained from one's own experience as a parent or grandparent.
No.
I mean, I suppose in some measure there are some things that could possibly fall into that category, but this is beyond
This is
it.
too technical.
When Dr. Cooling put his explanation before the court, which is the one you've put before the court
Yes.
as well, and is the one contained in paragraph 12, did the judge take issue with it?
My lady, I'm not going to be very helpful about this because I can't remember the minutiae of it. But he listened to it, certainly. I don't recall him cross-examining Dr. Cooling about it, if I can put it like that.
Well, can I ask you the same question differently?
Yes.
You obviously won't have instant recall because it's quite a long time ago now, but did the judge challenge Dr. Cooling in any respect? I mean, did he say, look, I don't really understand this because I've got a 4-year-old granddaughter or child? No?
He certainly didn't bring it back to that.
But he
To that
didn't
level.
challenge. I mean, there are two ways of
I'm just going to see
even
if
by
we can-
saying, you know, sometimes, I mean, we've all been in this sort of similar situation where you say, well, look, you know, the reason I've got you here, Dr. Cooling,
Yes.
is because I find this difficult to understand.
Yes.
Can you explain it to me
Yes.
in a bit more detail? Did he do any of that?
No. My recollection is that he said something along the lines of, would a 4-year-old really have appreciated this?
But how long was Dr. Cooling in the witness box?
Not very long. 15, 20 minutes, something like that.
And when he asked that question, is the answer that he gets the one that's contained,
Yes.
summarised in paragraph 12?
Yes.
Did he take it any further?
Not that I recall. He took it further with me when I was making my submissions, and I think you can see that. We had quite a long interchange about whether the control mechanisms were met and I used the comparator of the mother and to try and establish where the boundary was. And the fact that if it had been the mother in the window, she clearly would have been a secondary victim and would have been able to recover. And at that point, we do to have a discussion about what the child had appreciated at the time. And we did go through the evidence that had been given and the opinion of Dr. Cooley. And as you can see, he didn't like that argument because he turned it on its head in his judgment. So that was the closest that we got to a real discourse about how much understanding the appellant would have had at the time. And it became, at that point, it became very obvious that that was his real concern, rather than the aftermath or any of the other issues.
I mean, it sounds philosophical, but there must be a point at which a child moves in this situation from being somebody within the necessary legal proximity to the tortfeasor, moves from being outside the necessary proximity to the tortfeasor to being a person within the necessary proximity to the tortfeasor.
Yes.
And the control mechanisms must, it seems to me, not be read as deeds by a chancery lawyer like me. They must be seen for what they are, which is arbitrary exclusion mechanisms to make sure that not too many people can recover damages of this kind.
Yes.
And therefore you have to look at who are the people who can recover damages of this kind, and they are people who have a close relationship with the victim, and because of that close relationship, apprehend shock and upset as a result of the events which occur. So when you are a 6-month babe in arms, you may hear a loud bang, and you may see your mother very distressed by events which occur, but you're unlikely to suffer shock as a result directly of witnessing an accident or the aftermath of an accident in which your relative is involved.
Yes.
But at some point, the lens comes into sharper focus. And what I think we're all struggling with is at which point does that lens come into sharp focus, and when does the law say you should be able to recover because if the effects which you have suffered are discernibly caused by being, properly so called, a secondary victim of the accident,
Yes.
and therefore within the proximity of the defendant. Now, that's a very long way of saying it's not really a requirement for that the child appreciates anything. It's something to do with the relationship.
Yes.
Which is already in the control mechanisms,
Yes.
full square.
I mean, Alcock, as you will know from probably having it quoted in front of you many, many times, deals with this idea of a presumption in relation to a spouse or parent-child, which of course is rebuttable. And in my submission, that's the point here, that there is a presumption in respect of the very closest relationships, which is rebuttable. And for your note, Lord Keith makes that reference at page 397.
Can we look at that?
Yes. So Alcock is tab 2, page 37 internally. And the judgment of
so it's at 1, 2, 4.
yes, it's a 124, paragraph B, concept of a person being closely and directly affected has been conveniently labelled proximity. And then the main paragraph just above C. As regards the class of persons to whom a duty may be owed, to take reasonable care to avoid inflicting psychiatric illness through nervous shock sustained by reason of physical injury or peril to another, I think it is sufficient that reasonable foreseeability should be the guide. I would not seek to limit the class by reference to a particular relationship such as husband and wife or parent and child. The kinds of relationship which may involve close ties of love or affection are numerous, but it is the existence of such ties which leads to mental disturbance when the loved one suffers a catastrophe. They may be present in family relationships or those of close friendship, and may be stronger in the case of engaged couples than that of persons who have been married to each other for many years. It's common knowledge that such ties exist, and reasonably foreseeable that those bound by them may in certain circumstances be at risk of psychiatric illness if their loved one is injured or put in peril. The closeness of the tie would, however, require to be proved by the plaintiff, though no doubt being capable of being presumed in appropriate cases. The case of a bystander unconnected with the victims of an accident is difficult. Psychiatric injury to him would not ordinarily, in my view, be within the range of reasonable foreseeability, but could not perhaps be entirely excluded from it if the circumstances of a catastrophe occurring very close to him were particularly horrific.
Is that, those last couple of sentences we're not troubled with here, are we? But that they are, I think, unorthodox. I think the majority didn't go that far, did they?
They didn't go quite that far. And in fact, subsequently, there was a case which I haven't put into the bundle because it's not relevant for us, but there was a case involving Piper Alpha, and there were bystanders there when the Piper Alpha oil rig exploded, and the Court of Appeal said there was no liability there, even though the accident was particularly horrific.
But what you get out of that, I think, is that it is the proximity arises from the relationship.
Yes.
And there has to be a relationship which makes the fact of being involved in the aftermath of the accident more shocking than it would be to a bystander.
Yes.
And shocking in a way that makes the law recognise that the tortfeasor owed a duty to that person,
Yes.
where they wouldn't owe a duty to another person. And that point is about the relationship. It
Yes.
is the relationship. And what you can't do is where you have a 6-month baby, the relationship is not sufficiently developed to the stage where the tortfeasor can be presumed to know that a 6-month-old baby will be damaged by a shocking event, because that baby maybe will only hear the bang, the baby's not sufficiently conscious to realize that, not sufficiently sentient of events to associate what's going on with the things they sense. But you reach a stage, maybe fairly quickly in life, where you are. And
Yes.
it may be, as we see from, maybe from psychiatric evidence, that actually, as we all learn as we get older, children know a great deal more than you think, even when they can't talk.
Yes.
And so the real question is, when does that relationship reach a stage at which the proximity, at which the child is put within the proximity because of the relationship? relationship with the victim. And I suppose it will depend on the facts.
Yes.
Because,
Yes, my lord, I think one has to be really careful about this because a child, a baby in its mother's arms, who is dropped to the ground because the mother is murdered by a stranger in front of it, is perhaps in a different position. There may be a reaction in those circumstances, one just doesn't know without
sorry, you
in
have
the
to
case.
speak up, you've got competition
Yes.
outside.
There may be a violent reaction on behalf of the young child in those circumstances.
Yes.
Where there perhaps wouldn't be the same reaction of that particularly young child in this appellant's circumstances.
Yes.
So I think one has to be very careful about saying there is an age. It may be that...
Well, I said it depended on the facts.
Yes, it may be that it depends on all the circumstances.
So what you're postulating is, and this is a submission, as I understand it, that if the tortious act, let's not call it murder, is the mother being stabbed and the baby being dropped to the ground,
Yes.
it is entirely possible that nervous reaction suffered by the baby might be within the would make the baby sufficiently proximate to
Yes.
that tortfeasor.
It may be.
May well be. You can understand that. But in this kind of remoter sort of road accident or
Yes.
bombing like this case, what I've said may be right as well.
It may be right as well. But I think
So
one has
you
to be
never
careful
can
about...
generalise.
Exactly. I think one has to be careful about
Yes.
putting a line in.
I'm really, really concerned that we don't throw the cat amongst the pigeons in this case, just because the facts are very unusual,
Yes.
by making generalised statements
Yes.
about what 4-year-old or 3-year-old or any number of ages of children know.
No, I don't think you can generalise by reason of age.
And if we were to do what the judge said, which is to look for appreciation by a sentient appreciation by a child, then the 6-month baby in your example would be excluded, wouldn't it?
It may be excluded. I'm reminded, for what it's worth, and I take it that this is tenuous in circumstances, but the child bereavement documentation suggests that children start to appreciate and experience bereavement from 8 months onwards.
Well,
But I mean, it seems to me that
Bereavement is different again.
Of course it is.
Then that's simply
Of
the
course it
absence of
yes, a parent.
of a known
Yes, yes.
presence to
Yes.
which you have an attachment.
I completely agree.
So I think what this illustrates also is that we have here a case on not just unusual facts about the bombing, but unusual facts procedurally.
Yes,
We have very limited evidence, very limited exploration.
yes,
I'm not blaming anyone. It's how it all arose. But the fact is that this is not a case in which we have the kind of sophisticated evidence that would enable us to do more than decide how this particular case should have been decided.
yes,
I mean, this is a typical case of where courts love to expostulate about the law of a particular subject on a summary judgment case when they've heard no evidence and they know nothing. And judges, they go off to the Supreme Court, and the Supreme Court gives a 150-page judgment about the law of this subject when there's been no evidence,
no,
which is, not helpful. And as my Lord says, we've got to be incredibly careful in a case where there's no evidence in an incredibly unusual situation to lay down guidelines for what may be thousands of cases we know
Agreed.
nothing about. Your murder example, if I may say so, I mean, I think maybe... an attack is good enough. A physical attack is good enough. Is a very good example. You wouldn't have thought of that, and it may raise issues that are
Yes.
quite different from this case.
It-
So
it
all
really-
we're concerned about, we don't need to, it seems to me, rewrite the control mechanisms.
You don't need to rewrite the control mechanisms, no. Because the control mechanisms that allow this appellant to recover are already in place.
And you had the evidence.
And we have the evidence, yes. And there is a second issue, my lords and my lady, which is about what the role of the court is in circumstances where the defendant has decided not to attend and not to participate, compared with what the role of the court is when the defendant does attend and is unrepresented. And in my submission, they are different. And in the situation where the defendant does attend and is unrepresented, the court will generally assist the defendant with putting any challenge that the court thinks ought to be put to witnesses, and insofar as they can, make sure that the defendant has a fair trial, because that is obviously paramount, as compared to where a defendant deliberately absents themselves, and both Mrs Justice Yip and Mr Justice Martin Spencer agreed that the defendant had deliberately absented himself. Is it then open to the court of its own volition to expressly challenge uncontroverted expert evidence where there is no challenge there's no adversarial challenge? And the difficulty with not giving some assistance to the judges in that regard is that a claimant will usually assume that the evidence that they've obtained will be tendered because there are no points being taken on it. And what happened here was the expert evidence was in effect tendered to the court for its assistance, and the judge decided that there was a point that should be taken on it.
Well, it's not taking a point, it's understanding the ramifications, consequences and effects properly of the evidence. I mean, I'm not sure. I mean, the whole function judges fulfill is to achieve a just outcome.
Yes.
And if he felt that a just outcome could not be achieved without hearing from Dr. Cooling, he was surely totally within his rights to ask to do so.
He was, well, my lord, with respect, that's quite difficult. Yes, in some circumstances, it would have been right for him to require the attendance of a witness. But there has to be a good reason for that, other than I might not agree with an expert opinion, which is not the subject of any challenge.
This point. There wasn't an expert opinion on this point at the time that the trial started. There was expert evidence, but it didn't address this issue. In a way, what the judge was doing was being helpful to you. As I understand, he saw it. He thought a thing which on his view of the law needed to be proved was not covered by the evidence that he had heard. And he said, "Can we not hear from the claimant, from the doctor, who may plug this gap?" The oddity is, when he is called and gives the evidence, the judge doesn't accept it.
Yes.
But I think there's a respectable case. I'm not saying necessarily right, but if the evidence hadn't been called, the judge would have said that this issue isn't. You haven't proved, because the claimant herself doesn't say.
Yes.
I thought Daddy was among the people who might be injured, and I can't infer that on my knowledge of what a four-year-old would naturally assume.
Well,
I'm at the moment, I don't see any room for criticism for the judge in wanting to hear from.
I mean, I think the problem with what my lord is putting to you is the contents of paragraph 58 of his statement, which the judge had read, which says she, the child, was puzzled and worried about what had happened to her father.
Yeah. Well, maybe that's the answer.
And so there was evidence before, and you are saying, as I understand it, that in that situation, the judge really ought to have accepted it at face value.
Yes.
Now, I would challenge that. If the judge feels that it's something that he may be misunderstanding, surely, in order to make sure that justice is achieved, he's entitled to say, look, I will get a better understanding if I ask Dr. Cooling a few questions. I mean, not in a hostile way, not challenging from the defendant's point of view, but to make sure that he understands the evidence and accepts it. I mean, he that's his job.
Well, it is his job in some circumstances, I agree.
Well,
But
you have
it
to
would be
accept
more
evidence when the other side doesn't challenge you. You can accept any old evidence.
No, you can't accept any old evidence. Of course you can't. But you would expect a challenge in respect of, for example, an expert who wasn't properly qualified to give the expert evidence that they gave.
Sure.
Then absolutely it may be appropriate to have the expert called. Or where there is a very significant inconsistency in the evidence in the report, you might want to call an expert to deal with an obvious inconsistency. But actually here, the judge wanted the expert called to put what he thought was the better view, which was his view.
But he didn't do that. He didn't say, I know all about 4-year-olds and they don't understand.
No, he didn't. But by his conclusion in his judgment, that's exactly what he was doing, with no disrespect to him.
He didn't do that.
But that was
When
was the point of calling the expert, was to test whether or not this appellant could have had the requisite understanding that her father had been involved in the incident.
Surely
Because
he
that was the reason that he gave in his judgment.
But surely he was entitled to do that, test it, wasn't he?
Well, I mean, the Supreme Court recently, as you know, my lady, has said broadly no.
You mean the TUI decision?
In TUI, they say, in short, the report of Professor Pennington was flawed in material respects, but it still wasn't open to the judge to contradict it.
Well, you better show us that bit, please.
But contradict is one thing. I was taking at an earlier stage, I was saying test. This was a critical issue. Surely it was open to the judge to test the evidence.
Well, yes, I would agree with you where the defendant is unrepresented. But unless there is a real basis for doubting the evidence, so if you've got a respectable expert giving evidence within the realms of their expertise, then with respect, when the defendant has absented himself and doesn't seek to involve themselves in the case at all, I'm not sure it is open to the court of its own volition, save exceptionally, to challenge the evidence.
It is. This isn't that case, is it? The judge perceived an issue that he thought was important that was not covered by the expert evidence, which the expert had not expressed any opinion on what he thought was, in law,
Yes.
the crucial element, namely whether she would have appreciated that her father was in the might have been injured.
Yes.
It's true, as my lord rightly reminds us, that in his account of the history there was material that he might have relied on to make such an opinion, but he doesn't in the opinion part of his report address that.
No.
So this is really a case, it seems to me, where the judge saw a lacuna, or an arguable lacuna, something on which he wanted to have the best evidence he could get.
Well, if
He then got it and didn't
Yes.
agree with it, but
Yes.
that's another matter.
if I do appreciate that if there is a glaring omission, and it may be that the judge considered this was a
I
glaring
mean,
omission,
glaring, but just
An omission.
necessary on his analysis of the law.
or if there is, as I've said earlier, a difference of view depending on which part of the report you read, or if there is an issue about whether or not the expert has relevant expertise, then I can see that there is an occasion where a judge may require evidence to be given live. But it must be more exceptional in my submission than it is under CPR 31A, where a defendant is unrepresented. Because in those circumstances, there is a positive obligation on the court to make sure that there is a fair trial for an unrepresented party. And there must be less of an obligation where the defendant deliberately absents themselves. Not a less of an obligation because it still obviously has to be a fair trial, but the intervention should be exercised more guardedly.
Well, the circumstances are set out, the rules are set out in paragraph 70 of Lord Hodge's judgment in TUI,
Yes.
but ironically, it's really paragraph 2 that gives you the answer to this question, where he says, the appeal raises the question of fairness of the trial. The question is whether the trial judge is entitled to find the claimant had not proved his case when the claimant's expert had given uncontroverted evidence as to the cause of the illness, which was not illogical, incoherent or inconsistent, based on any misunderstanding of the facts or based on unrealistic assumptions, but was criticised as being incomplete in its explanations and for its failure expressly to discount on the balance of probabilities other possible causes. And the answer to that question was that the trial judge was not so entitled
That's right.
to do that. But the reality is all in, the law is all in those words. Uncontroverted, illogical, not incoherent, not inconsistent, not based on a misunderstanding of facts or on unrealistic assumptions. So if the judge thinks they may be,
Yes.
he's entitled to question, because as Lord Hodge says 3 times in this judgment, it's all to do with the judge having a fair trial.
Yes.
And it doesn't matter who's there or who's not there or who cross-examines, the process has to be fair. And, you know, that's my basic sense of justice says that.
Yes.
And so it seems to me you don't get very far by saying he shouldn't have called this witness. If he was genuinely wanted to ask him some questions to probe a little further, he was fully entitled to do that.
Yes.
The question where it seems to me you have a stronger point is whether he should have added his own expertise to that of the judge in an area of professional learning.
Well, there's 2 points about that. I don't demur from that observation. But actually, when you look at this case, none of those criteria set out by Lord Hodge was satisfied.
Well,
And so,
but there's another. I mean, you say that. I think that's colourable because illogical, inconsistent. He was concerned, not that it was inconsistent, but that there might be questions that would help him to understand it better, and that's perfectly proper. Surely. No?
my
Yeah, I
lord,
think
I'm
you said-
happy to accept that. It's a very favourable view, because actually there was no reference to this report being inconsistent. It clearly wasn't controverted by anybody. It didn't have any of the criteria that Lord Hodge said would be of concern. And the judge never said it did.
It's
I
not
mean,
the
the
same
bottom
case.
line
It's not
here
the
is-
same case, is it? The expert in Griffiths had addressed the very issue in the case. What was the cause of the gastric upset that they'd suffered?
Yes, and so
He may have done so. Then the question was, the point here is that the expert had not addressed what the judge thought was an important issue in the case.
well, actually,
So it's not. The two situations are not comparable.
they are comparable because the concern by the judge in Griffiths was that although they had dealt with causation, as Dr. Cooling had dealt with causation.
But Dr. Cooley hadn't dealt with causation in the relevant sense.
Well, if
He
I could
did-
just finish.
he-
They were concerned in Griffith with the fact that the expert had not excluded other causes. So actually there is a similarity across, and that was what the trial judge was concerned about, and that was why originally the claim was not proven. So it was a gap, or a perceived gap in the expert evidence perceived by the trial judge, which led to the appeals. And in fact, the Court of Appeal agreed that there was the gap, and the Supreme Court disagreed.
Well, there was a strong dissenting judgment in the Court of Appeal.
There was, yes, there was, from Lord Justice Bean. Very strong.
There was many strong judgments in that.
But he still lost 2-1.
I mean,
So
even TUI, I think TUI is interesting, but not really the point here. I mean, can we come to whether your appeal succeeds on the factual issue? Let's assume that the judge evaluated the expert evidence by reference to external information that he'd applied himself. Does that enable you to say that you meet the appeal standard when he is the trier of fact?
Sorry.
Well, this is a factual appeal. You're saying
Yes.
he got the answer wrong.
I'm
Normally
saying
we
he
don't
disregarded
normally-
expert evidence when he shouldn't have done, and he imposed his own opinion, which was a lay opinion,
Right.
on matters which should have been expert opinion.
And you also say that he was wrong.
And I say he was wrong.
Yeah. Okay. Yeah, well, that's a pretty simple point. We can get that.
My Lord, I mean, I have set out in more detail the law on secondary victims. I'm not sure we're going to be much assisted by that.
Well, you say that. I mean, I have maybe an unnatural interest in the law, Miss Studd, possibly to do with my position. But I think it's very important that we do hear your submission
Yes.
on why your client comes within the control mechanisms and whether there should be imposed a further requirement of any sentient appreciation, because that's not there in the control mechanisms.
Well, it's presumed in relation to certain relationships. Let me take you through.
Well, but I mean that's okay, presumed, but rebuttably, and
But
here
rebuttable.
we're then it's rebuttable if you're very young, right?
It could be rebuttable if you're very young.
Yeah.
Yes. It could be. It could be rebuttable if you're very young. It could be rebuttable if you have no relationship with the spouse or parent or child.
So you may not even know it's your for example, an adopted child might witness an accident by a person who happens to be their birth mother.
parent. Yes.
And they don't know it.
No.
They would be not within this
No.
control mechanism.
That would be similar to Young and McVean, which you'll find at tab 6. That's a case where a mother, it's reported in the Scottish courts reports. Young and McVean, 2015, CSH 70.
Then where it's reported. We've got that written down.
Yeah, and it deals with a situation where a mother comes across a car accident on her way to the gym and only becomes aware later that her son is in the accident. And I can just take you to, it's the case actually that comes closest to the position that Mr. Justice Martin Spencer wanted to put in place here. At page 274 of the pagination, paragraph 5 of the judgment, six lines from the bottom, particular wrong may cause loss to a number of persons, but only those who can establish the requisite relationship of proximity with the wrongdoer will fall into the class of victims who have a claim for damages against the wrongdoer.
Sorry, where are you reading?
I'm at page 274 of the internal pagination, 6 lines up from the bottom, under the heading A Secondary Victim Law.
Yeah, thank you.
Yes, at this point, Lord Brodie, if it is Lord Brodie.
It is Lord Brodie, yes.
He's dealing extremely generally. He's not even dealing with secondary victim cases at that point, is he?
Yes. And then he deals with paragraph 7. He deals with the general position, and then he says, that is the general rule. It's subject to an exception in the common law. The exception applies to cases such as the present case, where the affected person has suffered psychiatric injury, conventionally referred to as nervous shock, by reason of the contemplation of the death or physical injury to the primary victim. However, the exception does not apply to all such cases, subject to what Lord Wilberforce referred to as an extension to the exception, see McLaughlin and O'Brien. It only applies where the nervous shock has been caused by the shocked person being immediately and directly confronted through sight or sound of it by the primary victim's death or injury. And he then goes on to consider Alcock. And at paragraph 11, he turns to deal with the strict control mechanisms referred to by Lord Dyson, of 5 common features set out by Lord Oliver in the passage quoted above from Alcock and elaborated into 7 requirements by the judge at first instance in Taylor and Novo. And then he sets out Lord Dyson's control mechanisms referred to in Taylor. And at paragraph 12 on page 278, he says, we would observe that, as is clear from the context, when Lord Wilberforce uses the expression hearing of the event, he means direct auditory appreciation of what is happening, as opposed to communication by a third party. However, in addition to cases of shock coming through the seeing or hearing of the event, Lord Wilberforce recognised cases of shock coming through the seeing or hearing of its immediate aftermath as falling within the exception to the general rule. It was this admission of those shocked by reason of their having to come upon the immediate aftermath of the event causing the death or serious injury of the primary victim into the class of those whom Lord Oliver was in Alcock to describe as secondary victims that Lord Wilberforce in McLaughlin and O'Brien designated the extension to the exception. And then if we go on to the decision, paragraph 22, in the middle of that paragraph, as McLaughlin and O'Brien illustrates, if a plaintiff is exposed through her senses to the immediate aftermath of an event which has caused the death or serious injury to a close relative, and as a result of that sensory exposure sustains nervous shock, then she has a claim for damages. The horror of the immediate aftermath is treated in the same way as the horror of the original event. However, in keeping with that, if nervous shock on exposure to the aftermath of an event is to give rise to a claim for damages, the conditions for recovery which apply to nervous shock on exposure to an event must also apply to nervous shock on exposure to the aftermath. And this includes the requirement that the relevant injury to the secondary victim was caused by a shock as a result of what she perceived with her own senses. And at 24, page 284, we would regard the present case as being of the same nature as Lord Oliver's characterisation of Alcock. The pursuer saw the wrecked car but did not immediately associate it with any of her relatives. Only thereafter did that visual image provide the matrix for imagined consequences, giving rise to grave concern and worry, followed by a dawning consciousness over an extended period that the imagined consequence had occurred, finally confirmed by news of the death. Lord Ordinary said that she did not have to form a view on what she clearly thought had been an unduly narrow distinction, because the pursuer began to feel uncomfortable very shortly after viewing the wrecked vehicle. That may be, but when the pursuer viewed the wrecked vehicle, she had no reason to connect what she saw with her son. Indeed, as the Lord Ordinary found, her initial reaction was one of relief that her own children could not be involved, as her son did not drive and her daughter was at home. Thus, as far as the pursuer's perception at the time of viewing was concerned, the wrecked vehicle could not be the aftermath of an event which had had an injurious consequences for either of her children. That initial feeling of relief gave way not long afterwards to a feeling of increasing concern and worry for her son. But on the evidence heard by the Lord Ordinary and narrated in her opinion, it cannot be said that the pursuer suffered nervous shock as a result of viewing what might be described as the aftermath of the event in which her son was killed. It has to be kept in mind that what is meant by that admittedly somewhat dated expression, nervous shock, Lord Acton explained the concept in Alcock at 41F. And then he recites that well-known paragraph. And at 26, we do not take issue with the proposition acceded to by Professor Freeman in evidence that the pursuer's experience over what was a relatively short period of time had been ghastly, but it did not involve the sudden appreciation by direct sight or sound of a horrifying event, or direct sight or sound of the horrifying immediate aftermath of such an event. Coming upon a wrecked vehicle immediately after such a collision, and the knowledge that her son was involved in the collision which had resulted in the wreck, might also be equally horrifying, but that is not what occurred. The pursuer was unaware of any connection with her son when she saw the vehicle. So the case of Young does deal with the appreciation that the person was involved in the accident. But the reason why it's different is because it is more consistent with being told afterwards that her son had been involved in the accident, rather than appreciating it with proximities to time and place. Whereas here, we've got a different scenario, because we've got that proximity in relation to time and place. And the presumption here, given the facts, is that this claimant, this appellant, appreciated an involvement with her father. Lord Brodie goes on at paragraph 27. Lord Ordinary noted that the pursuer began to feel uncomfortable very shortly after viewing the wrecked vehicle, that her suspicions about her son's involvement began fairly soon thereafter, and that she was distressed prior to her confrontation with the police, who confirmed his identity. These events, taken together with other facts of the case, led her to conclude, after applying all of the relevant control mechanisms, that the pursuer should be classed as a secondary victim. We cannot support that conclusion. Lord Ordinary does not specify what she meant by the other facts of the case, but we take it she was referring to the pursuer having developed psychiatric illness of the nature of post-traumatic stress disorder or depression as a result of the distressing events of the 1st of June 2010. About that there is no question, but while psychiatric illness is a necessary element of a claim of this sort, its existence does not assist in satisfying the control mechanisms. A claim will only arise in the highly particular circumstances where the illness is as a result of a direct perception of distressing phenomenon. On the evidence as narrated by the Lord Ordinary, that did not occur here. The pursuer was not a secondary victim and accordingly is not entitled to damages in respect of her psychiatric illness. And with respect, Lord Brodie is very much endorsing my Lord's observation that this is about the relationship and the proximity of time and place running together. And in Young and McVean, although there are references to her not appreciating that it was her child who was in the collision, that is more about coming across the proximity in the sense of time and place rather than proximity in relation to the relationship. And of course, both of those need to be satisfied. In relation to the case of Paul, my lady stayed this case, as you'll be aware, as a result of the cases going to the Supreme Court in Paul. But in fact, Paul, with respect, doesn't really assist us with this appeal because, of course, in Paul and the cases associated with it, it dealt primarily with this issue about the accident. When is the accident as opposed to when is the death? And is it sufficient for children to witness the death rather than the original accident which caused the death? And the Supreme Court has made a differentiation and said that it's that temporal proximity which is vital before recovery as a secondary victim can be made. So that if you have an injury sustained but you don't die from it then and there, and your children witness your death 3 weeks or 4 weeks or 5 weeks later, then that is insufficient proximity for the purposes of categorisation as a secondary victim. So with respect, I'm not sure that Paul particularly assists this appeal.
Well, it does sort of set down the law for another generation.
It does, but not in relation to the issue which is problematic here.
Well, it does explain how the control mechanisms are intended to operate.
It does. Would you like me to take you to that part?
Well, I think it's just helpful to mark them, yeah.
Paul and another against the Royal Wolverhampton NHS Trust, together with Palmier and Purchase, reported at 2024 two weekly law reports, 417. The issues are stated in the
This
head.
is the court that is the most familiar with this case that you can possibly imagine, so you don't need to tell us the issues. But if we can just look at what they said about the way in which one uses the control mechanisms.
Yes.
Or what Lord Leggett said primarily.
Yes, paragraph 22 he deals with the it's not a dispute that such claims can be made in these cases. The claims in issue, however, are not claims made on behalf of the person who died for the harm suffered by that person. They're claims brought by close relatives of that person for harm which those relatives have suffered as a result of witnessing the person's death or its immediate aftermath. The critical question on which the validity of these claims depends is whether a doctor, in providing medical services to a patient, not only owes a duty to the patient to take care to protect the patient from harm, but also owes a duty to those close members of the patient's family to take care to protect them against risk of injury that they might suffer from the experience of witnessing the death or injury of their relative from an illness caused by the doctor's negligence. And then he deals at paragraph 26 onwards. He sets out the evolution of the claims, following through McLaughlin, Alcock and Frost. I perhaps pass over the earlier cases and deal with McLaughlin, which commences at paragraph 33.
Well, what he explains at 41 and later is that the control mechanisms which are generally taken from Lord Oliver's judgment in Alcock was identifying the common features of reported cases in which such claims had previously succeeded.
Yes.
And that's important because they were previously taken as a set of rules. And he said, Lord Oliver considered it must be from these elements that the essential requirements of proximity is to be deduced. And there weren't rigid lines of demarcation, no logical policy, blah, blah, for acquiring a marital or parental relationship and for precluding recovery in other cases, but the further pragmatic extensions of the accepted concepts had to be approached with great caution. And the point that I take from the whole theme of this judgment is that he's cautioning against construing these as deeds.
Yes.
He is saying this is all about whether there is proximity, and proximity is only one thing you look for. You're also looking as to whether there's a duty of care, which he cross-checks in his case and says there isn't.
Yes.
Now, but the important thing is that therefore you need not to approach these control mechanisms, because later Lord Dyson in Nova expands the 5 criteria, whatever you call them, I call them factors, to 7.
Yes, he does.
And if we are going to go through a box-ticking exercise of saying I've checked that box, and therefore I succeed, we may go wrong.
Yes, but the authorities do tend to suggest that particular relationships have a presumption of proximity, whereas others have to be capable of proof. And that comes from Alcock. It's not demurred from in Paul. And it actually meant that the brothers in Alcock, one brother did not recover for the death of another brother because their relationship was regarded to be normal.
And then there's the charming stuff about in 1968 engaged couples might have a necessary
I agree.
proximity. I mean, that's charming and historical,
Yes.
but it wouldn't be relevant today, which is why we have to keep in mind what we're actually doing. We are looking for a relationship. The relationship is a relevant part of the proximity. And it will change according to the facts and according to the generations in which we live.
But we're also looking at where the line is, where you have to call additional evidence to prove that relationship was strong enough.
Yeah, rebuttable presumption.
Yes. And the tenor of the case law suggests that in relation to a spouse or parent and child, you do not have to call that additional evidence per se. Whereas if it was a claim by a sibling, it would be expected that you would call the evidence from one sibling to say we had an unusually deep bond, and whatever the historical basis of that was.
But is that the real issue in this case? there can be no dispute that the claimant had a be technical, but qualifying relationship with her father. The problem which the judge perceived was that she, as he found, she didn't think at the time that her father had been injured in the accident of which she witnessed the aftermath. That's a slightly different point.
It is, but
and it's more like, as you say, the point in Young and McVeigh, which
yes,
is why you were at pains to distinguish it
yes,
in a way which I see the force of. But
yes,
still, it's actually a lot closer to that than the kind of point you're now making to us, that about, you know, degrees of closeness. And when you sometimes, nobody would say that the claimant had to be called to give evidence that she did, you know, that she was very close to her father, even as a small child.
yes.
We're on a different point.
The two are linked, aren't they? Because her relationship with her father, in fact, from the evidence, appears to have been a very close one, which will then have an impact on what her perception was of what happened when she saw him go and not come back.
Dr. Cooling refers to her father as being her main carer.
Yes, that's right.
Yes. But that's not the problem, really, is it? The problem is
Well, it might be part and
so
parcel.
I mean, suppose that she's seen all this, but her father had actually, odd facts, but not imaginative enough to different facts, had not been among the soldiers going out on that patrol. She thought, or she had no reason to believe he was.
Yes.
She hadn't waved goodbye to him. You know, last she'd seen him was in the flat. And it only becomes clear to her afterwards that he was. She sees this horrible event. Now, in those circumstances, we'd be much more like Young and McVeigh, wouldn't we? She wouldn't recover.
We might be in the Young McVeigh, yes.
The strength of your case is that she had every reason to believe, and, you know, a grown-up or even an older child would unquestionably, I mean, seen Daddy go out on this and
Yes.
seen that bit, unquestionably have made the association. The first thought would be, is Daddy all right?
Yes.
So that's the judge's point about appreciation, that because of her age, she didn't put two and two together in the way an older child would have done, and at once fear for her father's, but only discovers later, like the mother in Young and
Yes.
McVeigh. So I wonder whether we are in the same territory as the point that you're emphasising to us now.
Well, you can read it another way by taking the interpretation that he took. He rebutted the presumption that she would recover, because he wasn't doing it on the basis of.
Or you could, but the cases about rebutting a presumption are really about the cases where, you know, your wife is killed in a car accident, but actually the evidence is you haven't lived together for years, you got on very badly. No doubt it was a shock, but it was not the sort of thing that, you see what I mean?
But what about if your wife or your spouse suffered from a disability? So was perhaps unable to understand the full context of what had happened and what
You mean
he or she
if the
had
secondary
witnessed.
victim does?
Yes. So that would
The
be
truth
a
is, none of
rebuttable-
the cases are about such. But I would have
No.
thought that in
That
that
would be a
case you have
rebuttable
exactly the same. It had to be a quite severe disability.
Yes.
But
But it would be a rebuttable presumption, because normally she would recover without more.
yes, all right. But
And you
you'd
would
be
be
rebutting
saying
it for a
she
different
can't
reason.
understand.
You would be rebutting it not by saying the relationship wasn't as strong as you'd expect, but because of the particular disability, or in this case, the particular age, they didn't realise
Didn't
that that the primary victim
Yes.
was actually at risk.
Yes. But that is nevertheless a rebuttable.
Well, all right, but it's a very different
Yes.
issue. that you're rebutting it by reference to. Anyway, sorry, I just
This is
wanted
all,
to
it's all my
try that.
fault, because I wanted you to show me in Paul how they treated the control mechanisms. And you do get something out of the treatment in Paul about the way other judges have looked at it. And Lord Hoffman, for example, who's repeatedly referred to, said the plaintiff must have close ties of love and affection with
Yes.
the victim. Such ties must be presumed in some cases. And it seems to me we're probably all saying the same thing in different ways. The thing I'm balking at is introducing a new requirement of sentient appreciation. It seems to me that that is an essential component of the relationship.
Yes.
My lord is saying, well, the only thing that matters is, did they, at the time of the accident, know the loved one was involved? And since they didn't in McVeigh, the judge here was saying, well, it was the same here. I don't disagree with any of that, really. I don't think it matters which way you construe it. I just think it's very important to look at these various formulations of what rules people out on grounds of proximity, and refrain from making further rules that rule more people out or rule more people in.
Yes.
And you can only do that by understanding the underlying rationale of the control mechanisms, rather than the different formulations in which they're expressed.
Yes.
So, you know, it's perfectly clear one requirement is a close relationship. The reason why you need a close relationship is that sets you apart from somebody who goes out in the street and sees a terrible road accident and gets nervous shock.
Yes.
There's somebody who goes out in the street, sees a road accident, gets nervous shock, doesn't recover. Somebody who goes out in the street and sees their mother run over does recover. And the question is, quite simply, whether when you fall out of the proximity relationship. So, I mean, I think we've probably explored it as much as we can, Ms. Studd, but it's the reason I'm so concerned about it is that, you know, we've got to write a judgment which doesn't throw the cat amongst the pigeons, and you know, we do try and get the law right.
Yes. I should just say that Mr. Justice Martin Spencer wasn't referred to Young and McVeigh.
He wasn't the first to.
He wasn't referred to Young and McVeigh.
He wasn't.
No. He relied on Taylor, and he relied on the summary of Lord Justice Dyson at paragraph 2, I believe, of the judgment.
Yes, and he.
And he didn't.
He was before Paul, long before Paul.
It was before Paul. Yes. And he also. I mean, Taylor was a very different case again, of course, as they all are, aren't they? But actually, Lord Justice Dyson wasn't really dealing with the difficulties that we have here. And so just relying on an off-the-cuff remark when it wasn't really being considered at all was maybe unwise.
Well, the truth is, none of the cases involve
No,
the
they
particular issue
don't.
we have here, although, as my lord says, the underlying principles and rationale may give us the answer.
Yes.
But they weren't, none of them had to be concerned with this.
No. I mean,
Young and Remain is actually, Young and Remain is also different. So
that's right. And actually, as I said to you right at the beginning of the appeal this morning, I don't doubt that it would have been appropriate in this case, in other circumstances, to have had a child psychologist have a look at this.
But
child psychiatrist.
the strength of your case is, however we end up formulating this particular point, you say that if there was, whatever we choose to call it in the end, a duty, if there was a necessary element in your case,
Yes.
was that the claimant appreciated the risk that her father was involved in the accident of which she had seen the horrific aftermath. There was evidence which he should have held satisfied
Yes.
that requirement.
Yes. And it wasn't appropriate for him to substitute his own view in the face of that.
Yes.
My lady's got her pence already. I don't think I can assist you any further.
No?
No.
No? Nor do my colleagues, so thank you very much. Well, we'll take time to consider our judgments, despite the fact that we haven't spent very long on this. It's a complicated and important issue. We'll hand down our judgments in the usual way. When we do, please make any typographical corrections, and you won't have to agree an order with anybody, but please provide us a draft order reflecting the judgments. But thank you very much for your help that you've given us, and the same to your solicitors.